536, Eric Kosel versus State of Nevada.
All right, if y'all would like to make your appearances, please.
Morning, Your Honor. Ian McCloskey on behalf of the state, appearing under the supervision of Alicia Albritton.
And would you spell your name for me, please?
Yes, IAN-MCC-LOSKEY.
Mr. McCloskey. Okay, welcome. I'll talk to you in just a minute about your appearance here, because I'm just interested in it. Take a minute.
Sure.
Mr. Kozel?
Yes, sir.
All right, Mr. Kozel, go ahead and have a seat and relax. Mr. McCloskey, how is it that you're here? Under what rule?
I believe it's 49.5.
0.5. Right, I wrote it. I wrote that rule. It's a prior life story. Well, I'm glad to see people are using it. It was a great idea. I didn't come up with the idea, but I was asked to write the rule, so pretty cool. I kind of came up with it, actually, but who cares? Good to see people doing it. All right, in this appeal, Mr. Kozel, the appellant, was found guilty of malicious destruction of property by Judge Zimmerman. And as I take it, the mainline area of appeal is a sufficiency of the evidence claim. And so, I don't know if you know this, but I just want to let you know, Mr. Kozel, you can sit down and relax, that when you have a sufficiency of the evidence issue or claim in an appeal, the law does require that as an appellate court, I simply say that I have to view the evidence in the light most favorable to the prosecution and ask myself, could a reasonable judge, Judge Zimmerman, have found every element of the crime that you were convicted of beyond a reasonable doubt? And so it's a standard that is probably tough to overcome if you're the appellant, frankly, but nonetheless it has happened from time to time. And the way I like to do it is, of course, we have the record of the proceedings, I have the briefs. The idea is, where's the evidence from the record that would either support or not support the elements of the crime of malicious destruction of property. Now, of course, in looking at the briefs, I see that at trial, Twyla Kozel, or is it?
Yes.
Testified. She said she was there at the home the night before the incident around 11:30. She testified that there was no damage to her vehicle at that time. She then says that she saw you at around 6:30 in the morning drive past the vehicle, and testified that she then, contemporaneous or immediately thereafter, went out and looked at the vehicle and saw that the headlight was kicked and there was some sort of substance on the windshield. But mainly the concern, I think, was the headlight situation being broken. Then there's some text messages that Judge Zimmerman looked at, and as I see the record, there at page 12, there's testimony about some text messages that you'd sent. One said, quote, "That's one strong kick in your headlight." Then, "When did you see me? When did anybody see me?" And then there's another one that she testified to, "Was it your neighbor or you who saw me?" And so I will tell you that all of that is what I would describe as circumstantial evidence. There's a difference between circumstantial evidence and direct evidence. Direct evidence would be if anybody actually saw you or anyone else break this headlight. It doesn't seem like there's any evidence that is direct in that regard, so it's a circumstantial evidence case. And sometimes circumstantial evidence can be stronger than direct, or the other way around. But the point of it is, I don't see any direct evidence. It's all circumstantial, and so that's the way I see the appeal stacking up. It's your appeal. You want to add anything else?
No, Your Honor. I just wanted her to look into it. She stated in those text messages that her neighbor had seen me, and then a couple hours later it had changed to she had seen me.
Okay.
And I've just been going through this for 2 years, and I'd like to get it wrapped up.
Understood. Mr. McCluskey, you want to add anything to your briefing?
Your Honor, I believe that we briefed this issue pretty thoroughly, both with respect to the sufficiency of the evidence claim and with respect to somehow ineffective.
Do you think I have authority to handle that aspect of his ostensible appeal?
I'm not entirely sure as to whether or not you do from a misdemeanor appeal. My understanding is on the basis of, because it is a misdemeanor, that you do have proper jurisdiction.
I have jurisdiction, but in my view, I don't have any authority to deal with an ineffective assistance of counsel claim. There's a different legal procedural vehicle to handle that. This is not it, in my opinion. But I can handle the sufficiency of the evidence claim. Is there anything else you want to add having to do with that?
No, Your Honor, not this time.
Anything else you want to add?
That would be it, sir.
All right, I'm going to give you a written decision. You'll see a minute order come out. I usually tell people that's within a week. This time it's going to be within 2 weeks. And the reason for that is because my law clerk, who helps me with these things, has the unenviable situation in life of taking a bar exam. And so I'm giving him some time to do that. So you'll get a written decision probably within a couple weeks, okay? But by way of minute order. And the minute order will direct the prevailing party to draft the order. And if it's your side of it, I'll probably just draft it on your behalf, okay?
Be, Your Honor.
All right, have a good day. What's next?
Thank you, Your Honor.
Four, and that's case